Rajesh Singh sir, please begin.
So, a very good afternoon to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University. First of all, today's session, it is a guest session on online dispute resolution by Honorable Justice Mr. Rajesh Tandon, who is the former judge of Uttarakhand High Court. Now, let us talk about Honorable Justice Mr. Rajesh Tandon, sir. Honorable Justice Mr. Rajesh Tandon started career practicing as an advocate in the year 1968 and took the training in the chamber of Sri K.C. Agrawal, ex-Chief Justice of Rajasthan and Calcutta High Courts. He has held several important positions under the Constitution of India. Justice Tandon was appointed as a senior advocate in 2000 in Allahabad High Court, Additional Advocate General in 2003, Honorable Judge Uttarakhand High Court at Nainital in 2004. He is a presiding officer at Cyber Regulation Appellate Tribunal, Delhi in 2008 and member of the State Human Rights Commission, Uttarakhand till 2016. Honorable Justice Tandon has authored 4 books in the law and has also been awarded the prestigious uh, Sithik Puraskar on the famous book Muslim Vidhi in Hindi by the government of Uttar Pradesh. In its message dated December 14, 2011 to NBAI, member of Justice Rajesh Tandon reiterates that he looks forward to working with the legal community and that we need to work with the Government of India in bringing strong legislation and policy with respect to the Information Technology Act 2008. Furthermore, he was elected twice as a Vice President of the High Court Bar Association, Allahabad. He was also a member of Advocate Association, Allahabad. He has been an ex-Vice President of Uttarakhand Bar Association, appointed on the recognition day, and appeared as a senior advocate in various fresh petitions concerning the civil, criminal, constitutional, and rent control matter at Nainital and Allahabad High Court. He was a treasurer at Superior Law Institute and Allahabad and executive director of Indian Law Institute. He has also arranged seminar under the auspicious Vidhi Vichar Gosti, Nainital for last 34 years. Among the cases which has been transferred to Uttarakhand, maximum cases has been argued and conducted by all the natures, that is the second appeal, civil revisions, writ petition concerning his devotion to the profession for the last 35 years. Author of the law books, that is the commentary on the Rent Control Act, UPZA and LR Act, Dowry Prohibition Act, and he retired on 36 2008. Further, uh, honorary books was done by Honorable Justice. He was twice awarded Education Excellence Award at the Rotary International District 3120 and 3100 for the services rendered to the society. In the field of sports, he has been taking part in the golf tournament as a member of the Governor's Golf Club Nainital. During the tenure as a High Court judge, he was nominated as the chairman of Mediation Center High Court of Uttarakhand at Nainital. He was the chairman of the Legal Services Committee of the High Court of Uttarakhand on 4/1/2008. He was a chairman Advocate Chamber Allotted Committee, High Court of Uttarakhand Nainital. He was a secretary International Law Association. He used to dispose of 40 to 50 cases per day during the period of the judgeship at the High Court. He was the vice chairman of Amity Institute of Cyber Law and Cybercrime, Amity University, Noida, UP, in 2011. He was appointed as the chairman of the Higher Technical Education of Uttarakhand on 23rd 11 2011. 1st July 2016, he joined the Supreme Court Bar as a senior advocate. Awarded Diploma in Cyber Law by the Government of Law College, Mumbai and Asian School of Cyber Law, Pune on 1st March 2010. He was further also awarded PG program in Cyber Law by the Asian School of Cyber Law, Pune on 1st July 2010. Honored UP State Intellectual Honor of UP Ratan in the event of 28th Annual Celebration Year 2009 held by All India Conference of Intellectual on 13th September 2009. Awarded PhD degree from the Open International University for the Complementary Medicines, Mumbai on 1/2/2015. Awarded honorary professor, uh, just a minute, on 6/8/2015. Now coming to further about our provost, who is the vice chancellor of Parul Institute, Parul University. So he is just joining in few minutes. Just I am giving the short description of Ahmed Patel. He is the provost of this university and he is working since last 5 years. Now I will go to our dean who has recently joined 2 days back. Dr. Namita Vyas Joshi is the dean at Parul Institute of Law, sir. And about Namita Vyas Joshi, Dr. Namita Vyas Joshi is presently serving as the dean at Parul Institute of Law, Parul Institute, Vadodara, and it is an experienced professor with a demonstrated history of working in the higher education. She has completed her PhD law focus in the criminal law, business law, and constitutional law from the Vikram University, Ujjain, Madhya Pradesh. Her area of expertise including the criminal and constitutional law. She has worked with the eminent institutions like Renas University, Madhya Pradesh as a head of the law, Oriental University, Madhya Pradesh as an associate professor, and Amity University, Mumbai as an associate professor. Apart from this, he has also authored several research papers of national and international reputed journal. So on this note, I am just closing that this introductory part. Now I will tell Disha Pandey to proceed further. Yes, Disha Pandey.
Yes, good morning, sir. I would request Dean ma'am to say a few words.
Yes, Namita ma'am, your voice is.
Sir, there is some, thank you, Disha
Yes.
ma'am, and welcome, sir. Welcome, Rajesh, sir. Thank you very much for giving me the opportunity to speak some words. Uh, we all know that. Am I clear? I think Rajesh,
Yes,
sir.
yes, ma'am. Yes, ma'am.
We all know that today we are discussing about the criminal based on the dispute resolution. Okay. So if you talk about like dispute resolution, that is simple and
उनकी तरह से दिक्कत है नमिता मैम
tool for the dispute resolution, and it is not governed by the strict rules of the evidence procedures, but this allows the parties to participate in the processes and that can be molded to suit needs. And it generalizes the constructive approaches rather than the adversarial ones. And simultaneously, this online dispute resolution reduces litigation cost. So, sir will be brief on some points. So, and the cost of the compensation and the process are given to the neutral evaluators, and are this generally borne equally by all the parties that are providing the with an equal sense of the ownership and the equal say in the outcomes. So all the detail will be the brief by the sir because the sir is there and the expert is present here.
Yes, Disha Pandey.
Justice Rajesh Tandon sir, and please say words on this because I'm very just very puzzled as I saw such learned personality and I'm not able to say words. Please sir.
Thank you so much,
Yes,
ma'am.
over to you.
Thank you so much, ma'am. Sir, we would request you to please start.
Okay, thank you. First of all, I welcome the newcomer in your Parel University, Srimati Nandika ji, who has come from Amity University, where I have already been associated with the Amity University Noida,
Thank you.
and therefore I have high regards for the Amity institutions because Amity institution has given me the as a token professorship from Noida University also, from Dubai University also. I have been awarded from both the places the professorship, and therefore I have high regards for Amity University, and you being the professor of Amity University, I have high regards for you also, and regard to Dr. Rajesh Singh also, who is taking so much interest in the matter, regards to Vice Chancellor also, and everybody who is here, and Disha Pandey ji also is speaking very comfortably
Thank you.
and very good speaker, and she has introduced everybody. Now, the topic of today is very interesting. I salute to every students who are present here. These students, there was a time when CPC, Evidence Act, and only IPC, these were prevalent. Those time had gone away now. Now the time has taken a complete change. The change is that first of all, in 2000, information technology was introduced. Under the Information Technology Act, when it has come in the year 2000, nobody was aware. Technology Act. Nobody was aware that it will take Information Technology Act. Nobody was aware that the Information Technology Act will lead to the present system when it has introduced communication device, that is under section 2HA. Communication device means cell phones, personal digital assistants, or combination of both, or any other device used to communicate, send, or transmit any text, video, audio, or image. Then computer means any electronic, magnetic, optical, or other high-speed data processing device or system which performs logical, arithmetic, and memory functions by manipulations of electronic, magnetic, or optical impulses, and includes all input, output, processing, storage, computer, software, or communication facilities which are connected or related to the computer in a computer system or computer network. Then under section 4 of the Information Technology Act, at that time when it was drafted, that was in 2000 when the act was introduced, this section 4 was completely dormant. Nobody was aware that section 4 will come into play after this COVID of 2020, when the entire work was going, and still nobody is pursuing the physical. Everybody is going on online, not offline. When section 4 was drafted in 2000, when the act has come, that is Information Technology Act, where any law provides that information or any other matter which shall be in writing or in the typewritten or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form. Rendered or made available in an electronic form. Now everybody is going on electronic form, whether it is an institution, whether it is a court, or everywhere this 4A has come to be introduced as a rendered or made available in an electronic form. Electronic form, I have just read before you, that is the computer system, that is the electronic form. Any communication device, that is electronic form. I can also talk to you on a telephonic talks and also on video conferencing. Now everything is going on online. That is the subject of today. That is online dispute resolution. That is online dispute resolution. We can talk by mediation, conciliation, or arbitration by sitting online, as we are going to teach the students, or talking to the students, or talking to the Parul University. All this are online today. Now when I come to the Arbitration and Conciliation Act, either it is offline or online, whatever may be, but the act itself is in printed form. It is not online. It is a book, complete book of 1990s. That Arbitration Act has come up in the year 1996. I will just cite before you the genesis of the Arbitration Act, how it has been introduced before you. The law on arbitration contained in 3 enactments: the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and the Foreign Awards Recognition and Enforcement Act 1961. The Arbitration Act 1940 was widely felt to have become outdated, and then the Law Commission of India and the United Nations has introduced this Arbitration Act 1996 by coming to a model law. The law adopted the model law on international commercial arbitration. The General Assembly of United Nations had recommended that all countries give due consideration to the said model law and use the conciliation rules in cases where the disputes arise in the context of international commercial relations. Now then, the model law, India was one of the signatory for the model law, and the conciliation that was of United Nations Commission on International Trade Law also there. On 16th of January 1996, the Arbitration and Conciliation Ordinance was introduced, and then the Act has come into operation, and now it is known as Arbitration and Conciliation Act. Out of this, how it has been adopted, that was the Conference of the United Nations Commission on International Trade Law, that is known as in short form UNICETRAL, that was adopted in 1985, and then Model Law on International Commercial Arbitration, and the General Assembly of the United Nations has recommended that all countries should give consideration to this model law, and in view of that, the India has also adopted this as an Arbitration and Conciliation Act 1996. Therefore, the Arbitration and Conciliation Act was a replacement of the Act of 1940, where different methods were given. That was a method which has taken much long time even to complete the entire processing. And now this objective of the bill was introduced, and objective of this act was introduced, that is comprehensive, that is to make provision for procedure, to make provision to give that the tribunal should decide the matters, and it to minimize the supervisory jurisdiction of the high courts and all that. Now that high courts and Supreme Court are adopting this method of arbitration by sending the matters to the high court judges, retired high court judges, Supreme Court high court judges. Now this is just a provision of the Arbitration and Conciliation Act. but what are the guidelines that has to be seen? The students, you have to see as to how this will crop up, how this will crop up, and how the arbitrator will deal with the matter, how he has jurisdiction to decide the matter. For that purpose, you have to see the arbitration means. Section 2A means any arbitration, whether or not administered by permanent arbitral institution. Arbitration agreement, that is the main thing you have to see. Therefore, arbitration agreement is the genesis of giving the tribunal a jurisdiction to decide the matter, and therefore I will come first to section 7, how the arbitration proceedings start. Section 7 deals with the arbitration agreement. Arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen on which may arise between them in respect of a defined legal relationship. Now, this is a giant of everything arbitration proceedings. For starting the arbitration proceedings, an agreement has to be there. Now, agreement, how it will be enforced, how it will be drafted, and what are the contents of the arbitration agreement, that has to be seen. Now, that section 7 itself defines that arbitration agreements may be in the form of an arbitration clause, in a contract, or in the form of a separate agreement. There are two things. Suppose a contract has been instituted between the builder and somebody, engineers and all that. That agreement, that contract for making the superstructure of the building, then in that contract, that can be mentioned that if a dispute arises between the parties, then the matter shall be referred to the arbitrator. Now, or in the form of a separate agreement. Suppose a contract has been instituted long ago. At that time, the parties were not aware that the minimized litigation, that the minimum litigation, shorter route of litigation lies in arbitration proceedings. Then the two parties can join for agreement, separate agreement, and for that purpose, clause A of section 7A provides either it is mentioned in the contract or it is mentioned in a separate agreement. Therefore, the agreement is the sine qua non for proceeding of the arbitration proceedings. If there is no agreement, then the things will be different. Now, suppose there is an agreement. How this agreement is entered into, that has also been emphasized under section 7 of the Arbitration Act. First of all, it says that an arbitration agreement shall be in writing, where both the parties will agree that our dispute has arisen. If any dispute has arisen, the party will refer the dispute to the arbitrator. That is in the writing. And in the agreement itself, the name of the arbitrator sometimes are given, sometimes not given. Then it is left with the consent of the parties, of both the parties, whether the other party will require a retired judge or MD of the company or general manager of the company, whatever may be, that may be left with the discretion of the parties. Then arbitration agreement is in writing, which is contained a document signed by the parties. Both the parties will sign that is the agreement, and parties will enter into the agreement with the signature, their signature. Or if the signatures are not there, suppose that has come to the mind, in the mind of the two persons, that the agreement, if we cannot execute, somebody residing in Delhi, somebody residing in London, Mauritius, or wherever, then another mode has been given under Section 7 of the Arbitration and Conciliation Act, that is an exchange of letters. One can send a letter to the America, one send a letter to the England or wherever the parties are. And now the letters have also been made easy by sending online, that is electronic media. That is why I have introduced first the Information Technology Act before you, the communication device which I have introduced before you, that has also taken the shape in the Arbitration Conciliation Act. That is exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means. That is communication by electronic means. The Information Technology Act has come into play. The communication device which has been defined under the Information Technology Act, or under the definition section 4, that is rendered or made available in an electronic form, has also been made available under the Arbitration Act, that is the exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Then the matter can be referred to the arbitrator. If all these has come into force, then only the arbitrator will get jurisdiction to decide the matter. Another form has also been given under Section 7 of the Act, that an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other party. That is also a oral communication between the parties, and therefore the arbitrator gets jurisdiction after the proper agreement, either by telecommunication, electronic form, or otherwise, that has been entered into. That under Section 8 of the Arbitration and Conciliation Act, the parties can refer the matter to the arbitration, whereas there is an arbitration agreement. Arbitration agreement has come up from Section 7, and reference has been made under Section 8 of the Arbitration Act. This is the entire proceedings of starting the arbitration proceedings. And then the court has power, that has also been given under Section 11. The Arbitration Act is complete, that is the appointment of the arbitrators. There are several institutions just like ICI, SCOPE, and then the greatest institution is the High Court or the Supreme Court, where they assign the arbitration matters to various persons. If there is an agreement between the parties, the party can also exchange letters for referring the matters to the arbitrator under Section 8. That procedure has also been defined, that is under Section A11 of the Arbitration Act. The parties are free to agree on a procedure such as failing an agreement referred such and such, the arbitration with the 3 arbitrators. Each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. Now, further it has been, if the appointment of the arbitrator, that is from the High Court jurisdiction, and the party fails to appoint an arbitrator within 30 days, that is, if in the agreement it has been provided that so and so will be arbitrator. and party fails to appoint any arbitrator within 30 days, then the court has power to appoint the arbitrator under Section 11 of the Arbitration and Conciliation Act. That is the procedure which has been given, and that appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court or in the international commercial arbitration or by the High Court. High Court has also designated an institution, that is the institution of arbitrations and all that. They designate, and the High Court also designate for the appointment of the arbitrators. This is the simple procedure where the power of the appointment of the arbitrator and the procedure has started. And then the composition of the arbitration tribunal, that has also been defined under the Arbitration and Conciliation Act, and the arbitration proceedings start. And the very purpose is, when the arbitration proceedings have started, the court has also power, and the tribunal, that is the court also, he has got power to pass interim orders under Section 17 of the Arbitration Act, and that power has been conferred to the tribunal by virtue of Section 17 of the Arbitration and Conciliation Act, which provides a party during the arbitration proceedings apply to the tribunal for the appointment of a guardian for a minor or person of unsound mind for the purposes of arbitral proceedings. An interim measure, the preservation, interim custody or sale of any goods which are the subject matter of the arbitration proceedings. Securing the amount in dispute in the arbitration. Suppose somebody has filed the claim petition that is so and so amount, that is 2 crores amount, are due with the other gentleman who is a party to the agreement. Then the tribunal has power under Section 17 of the Arbitration and Conciliation Act to preserve the amount. That is, he may take a bank guarantee, or he may take any other procedure of adopting that the money is secured. And therefore, under Section 17, the orders are passed, and suppose Section 17 provides, that is, in many of the arbitration matters where the money was involved, that is 100 crores money was involved, then the party also files an application that the attachment may be passed. Suppose it's a government company or private persons or some office is there, and that owes a money of 100 crores, 50 crores or whatever. Then the power under Section 17 can be also exercised for attaching the entire goods of the company, or attaching the amount of the bank from the bank, also attaching the pay of anybody. Anything can be done, but these all the procedure which can be adopted under Section 17 after hearing the parties. And then Section 31 provides, that is the arbitral award can be passed under Section 31, and 31 also provides two methods. First of all, that either it can be a final award or it can be an interim award. Subclass 6 provides that the arbitral tribunal may at any time during the arbitral proceedings make an arbitral award or any matter with respect to which it may make a final arbitration. So, suppose a final, just I give example, the students. Suppose party has filed a claim petition demanding 50 lakhs of rupees or 50 crores of rupees, whatever they be. Then interim award can be passed for directing to deposit a 17 lakhs, 20 lakhs, 25 lakhs as an interim measure, and then the matter can proceed further. Or it can be a measure that the suppose parties are willing to pay amount. Sometimes it comes, that is the bank loan and all that. Parties admit that this amount was taken and this amount is due. Then by way of interim measures, the interim award can be passed, that this interim award is passed to this extent, that the parties will deposit the amount, the other party will deposit the bank loan or any loan taken within a period of 6 months, 1 year, or 2 years, and if the amount is deposited, then the interim award shall also, the final award can also be passed, or the interim award may be treated as the final award. Therefore, the procedure is that before starting the arbitration proceedings, a claim petition has to be filed, a defense has to be filed. In the defense, suppose he admits that yes, loan was taken from the bank and the amount is due, but he is saying that some negotiation can take place between the parties in order to settle the amount. That procedure has also been given under the Arbitration and Conciliation Act. That provision is under Section 30 of the Arbitration and Conciliation Act, that provides that the parties can enter the settlement. Suppose, which I have given example, that the bank loan has been taken by the party to the extent of 2 crore, 4 crore or 6 crore, and huge interest has accrued on that amount. Suppose he has taken a loan of 2 crores rupees, but it has accumulated to the 6 crore and 7 crores because of the penal interest which have been put by the bank authorities or anyone from time to time. Then the procedure has been also laid down under Section 30 of the Arbitration and Conciliation Act, which provides that it is not incorporated with an arbitration agreement for an arbitral tribunal to encourage settlement of the dispute, and with the agreement of the parties, the arbitral tribunal may use mediation, conciliation, or the other procedures at any time during the arbitral proceedings to encourage settlement. If during arbitral proceedings the parties settle the dispute, the tribunal shall terminate the proceedings and requested by the parties and not objected by the tribunal, record the settlement in the form of arbitral award on agreed terms. That is, if the parties agreed that I will pay the capital amount, but the interest may be discharged, or interest may be somehow maybe lesser interest instead of penal interest, then the bank has also right has been given to the bank authorities to settle the dispute by taking the initial amount which has been given on loan, that is 2, 4, 6 or whatever may be, and he may also exempt the other party from paying the penal interest, because penal interest accumulates from time to time, that is from the day when it starts, that is the date when the loan has been taken, from the date up to the payment, the interest makes more than the capital amount. Or um, I was just reading in a newspaper that one party has taken 16 lakhs 10 years back. Now it has accumulated to 16 crores by penal interest and all that. These are the examples, and for that purpose, Section 30 has been in the statute book for settlement, and for that purpose, arbitration proceedings, conciliation proceedings, and all that can be adopted. I may just point out to you that this CPC, this section, this Arbitration and Conciliation Act is coming up not only under the Arbitration and Conciliation Act, but under Section 89 of the Code of Civil Procedure also. The civil procedure is of 1908, but Section 89 of the under Part 5 has come up in 2002. On 1st of July 2002, it has been introduced, that is settlement of disputes outside the court. That is, after this 1996 amendment under the Arbitration Act, this settlement of disputes has come into picture. Now, therefore, what is the crux? Crux of the matter is that every civil court has been given power to decide the disputes by way of settlement, arbitration, and also by mediation. Now, Section 89 provides settlement of disputes outside the court, where it appears to the court that there exist elements of a settlement which may be acceptable to the parties. The court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations of the parties, the court may formulate the terms of the possible settlement and refer the same for there are three things: arbitration, conciliation, judicial settlement, including settlement through Lok Adalat, or mediation. Where a dispute has been referred, then 89 subclass 2, subclass A is very important, where a dispute has been referred for arbitration or conciliation. The provisions of the Arbitration and Conciliation Act 1996 shall apply as if the proceedings for arbitration or conciliation were referred for settlement under the provisions of the Act. That is, if the dispute has been referred under Section 89(2) for arbitration, then it will proceed like the Arbitration and Conciliation Act, and the settlement can be made under Section 30 of the Arbitration and Conciliation Act. This is a provision. Now, when I'll come to the Section 89(2), I will just cite there was a judgment of the Supreme Court in Salim Advocate Bar versus Union of India. In this judgment, the Supreme Court has said one of the modes to which the dispute can be referred as arbitration is Section 89 subclass 2 provides that where a dispute has been referred for arbitration or conciliation, the provisions of the Arbitration and Conciliation Act 1996 shall apply as if the proceedings for arbitration or conciliation were referred for settlement under the 1996 Act. Therefore, the 1996 Act has got priority because it is a central act, and all other agreements or other settlements are governed by the 1996 Act. Therefore, the Supreme Court has also said that it will be governed under the provisions of the 1996 Act, where Section 8 of the 1996 Act deals with the power to refer parties to arbitration where there is an arbitration agreement. This is a judgment of the Supreme Court. The Supreme Court in the Salim Bar Association has also defined the various methods as to how alternative dispute resolution and mediation rules have been framed and how this works out. And the Supreme Court has also defined what is the settlement, what is the mediation. Settlement by conciliation has also been defined. Settlement by conciliation, the Supreme Court has said, and settlement by arbitration has also been defined in a judgment of the Salim Bar Association. The Supreme Court has said settlement by arbitration means the process by which an arbitrator appointed by the parties or by the court, as the case may be, adjudicates the dispute between the parties. Then settlement by conciliation means the process by which a conciliator who is appointed by the parties or by the court, as may be, settle the disputes between the parties. That is also under the Arbitration and Conciliation Act. Then the mediation means the process by which a mediator appointed by the parties or by the court mediates the dispute between the parties. Now, therefore, all these things have been defined by the Supreme Court in the Salim Bar Association case, where the emphasis has been given that whatever the procedure is being adopted either under CPC section 89(2) of the Code of Civil Procedure or by any other means, the process of the same will be same. That is, under the Arbitration and Conciliation Act. Now, the Supreme Court has further in Cornack Railway Corporation versus Rani Construction Private Limited, that is on 30th of January 2002, the Supreme Court has also defined how this arbitration act has come into force and how it is enforceable in place of 1940 Act and unilateral model law, that is the international trade law, has been followed by the India and other countries also. The Supreme Court has said, that is in Cornack Railway Corporation, that the unilateral model framed by the Commission on International Trade Law established by the United Nations, if a comparison between the section 11 and section 11 of the model law, it is apparent that the act had designated the Chief Justice of a High Court in cases of domestic arbitration and Chief Justice of India in cases of international commercial arbitration. The nature and function performed by the Chief Justice are designate being essential to aid the constitution of the arbitral tribunal. It could not be held to be a judicial function, as otherwise the legislature would have used the executive court or judicial authority. It was therefore held that order under section 11 refusing to appoint arbitrator was not amenable to jurisdiction. This is the observations of the Supreme Court with regard to what does it mean section 11 and what does it mean the order which has been passed by the referring. Now therefore the court has been given under section 11 whatever may be the reasoning given in the Cornack Railway, when the power has been given to the Honorable Chief Justice and that power has been taken from section 11 of the Arbitration and Conciliation Act, and therefore the power to refer the dispute is there to a institution or to a judge or whatever may be for decision on this subject matter of the agreement, whether the agreement was there or not. That will be decided under section 15 of the code of section 1615 of the Arbitration and Conciliation Act. This is all under the Arbitration and Conciliation Act. This is procedure to be followed, and how the thereafter various judgments of the Supreme Court are there, where it has been the contract has been interpreted and the price escalation has been interpreted by the Supreme Court. When the claim petition comes and defense taken, claim petition usually comes with, because of this, that the claim was granted in 2002 and now it has continued up to maximum period and thereafter also holding over. Then the prices have increased and therefore the claim usually comes for charging the escalation and all that and raising of the prices. All these come under the disputes of the Arbitration and Conciliation Act. The vast can be said, more things can be said, but that will take a complete session of the whole day, and therefore I salute to all the Vice Chancellor, I salute to Dr. Rajesh Singh, I salute to the Dean Faculty, and I salute to the Pandey for organizing such a good seminar. Thank you very much.
Our provost is joining right now. Just sir, 1 minute. He is joining right now. So just sir, for 1 minute, just I am just sending again link because sir has some problem in joining the link. So sir, just 1 minute. I am just connecting with our pro vice chancellor. Sir.
चला आधा घंटा चला कितना चला आधा घंटा चला 40 मिनट काफी क्लियरिटी हुई होगी इधर बैठ जाते ना तुम सामने भी देखते रहते कुछ इधर से दिखाई नहीं पड़ता होगा अच्छा ठीक चलो बैठे
आईटी एक्ट वाला तो मेरे को पता नहीं था आईटी एक्ट आ गई तो सरप्राइज था
हेलो दोगे कुछ सुनो हेलो लाए इसको भी दो
Disha, you can start with question answer session. Sir is joining in 2 minutes.
Sure, sir. Okay, so thank you so much, sir. It was really enlightening to listen to you. I would request if any faculties or students have any questions, they can ask.
Mr. Rane, Mr. Vinod Ankush Rane, you can put up the question with sir. Sir, he is the LLM student and he has done his dissertation on online dispute resolution itself. So, sir, he is going to ask a question to you. Over to you, Mr. Ankush Rane.
First of all, thank you all the dignitaries and respected sir, Justice Rajan Tandon. Sir, my question to you that I have submitted my dissertation on my ODR, the ODR my subject, and in that subject I have given some suggestion. I have listened your Arbitration Conciliation Act and enlightening about your Arbitration Conciliation Act. But do you agree with that? My opinion about that there is a need in amend the Arbitration Conciliation Act for the ODR purpose.
Yes, that is right. That is why I have referred, first of all, before you, section 7. Have you seen this? An exchange of letters, telex, telegrams, or other means of telecommunication. Word is that has in 2016 it has been added, including communication through electronic means. That has been borrowed from information technology. That is, your subject is completely covered. That is inserted by Act number 3 of 2016 with effect from 23/10/2015. That is telecommunication, that including communication through electronic means, which provide a record of when the electronic communication has provided a means of setting out the agreement between the parties, then online dispute resolution is there. Everybody is doing online resolution. The arbitration also is proceeding online. Number of cases come online. Therefore, I agree with you that it requires, Arbitration Act also requires online dispute resolution. All that has to be separately, it has to be worded under section 7A. That has to be worded under section 7A, and therefore I have high regards for your thesis on this subject, and I will also suggest the university concerned to write to the government of India for including 7A, that is online dispute resolution.
Thank you, sir. And my second question is, my sir, as you are aware about that right now when you are we are doing this webinar in online, there is a network issue. But in suppose in remote area where the even we can say in the rural area there is a where there is a network issue. So how can this ODR can be virtual, and how can the ODR can be effective for the rural area?
For that purpose, I am not the minister concerned of that, and therefore I cannot reply you. However, you can write to the government for giving all facilities to the villages and all that. And I have the least to say in this matter because I have no jurisdiction to cover these things in the villages and all that places. Wherever the network will be there, our online, your online, or any dispute can be, public can enjoy the online, but where there is no network, I can't help it. I'm sorry.
Thank you. Thanks a lot.
पांडे
Thanks.
जी हंस रही हैं,
Thanks a lot. Sir.
दिशा पांडे हंस रही हैं, लेकिन मैं क्या करूं बताइए, मुझे मिनिस्टर बना दीजिए तो मैं सब जगह कर दूं, हैं?
Right, sir, right. So we have one more question from a student. The question is that these days, during the COVID times, we see that there are so many online dispute resolution bodies which are booming on the internet. So how
Yes.
do we trust that which body you should be approaching to for the online dispute resolution things? This is the question, sir.
I have not heard anything about this. Maybe that private organizations may have organized, that is, maybe in the cyber cafe and all that, they have organized this, and that is, if the cyber cafe has organized this, that has also been borrowed from the Information Technology Act. That under the Information Technology Act, there is a provision also for cyber cafe, that is under section 2NA, that has also been introduced, that is Act 10 of 2009. It provides that the cyber cafe means any facility from where access to the internet is offered by any person in the ordinary course of business to the members of the public. This can be an organization where they can work out in relation to the communication device and providing network. There are no other associations online to my knowledge.
Right, sir. Thank you for the answer, sir. Rajesh, sir, any more questions? Anyone, if someone wants to ask?
Sir, I have one more question. Sir, as in the pandemic situation, we found that this online dispute resolution is a very fast mechanism in
Yes.
resolving this problem. Sir, what is your take that in these conditions, right now we do not have any this pandemic situation, and now the courts are there, but still the procedure is long. So, what is your content on? What is your take on this, sir? That whether this is to be more emphasized on online?
To my knowledge, that is why with the beginning I have said that Information Technology Act has come into force in 2000, and nobody was aware that in 2020 it will be taken as a full force. Section 4 of the Information Technology Act, definition of that is communication device, and if it is adopted and some amendments are made under section 7A or under definition of the Arbitration and Conciliation Act to make effective online subject and all that, that will be very good. And nowadays, everywhere arbitration proceedings are going on online, the courts proceedings are going on online, and one of the institutions where I have just inaugurated as a PCS for training, they have also said that we are still on online. They will start it from offline August, If every pandemic situation will be all right, then only. Therefore, the government of India should take measures and initiative to make online resolutions and all that, and make it effective and make it progressive also, and make it network be available to all the places where we can work out for the online resolutions. Thank you.
Thank you, sir. Rajesh sir? Rajesh sir, can you hear me?
Yes, Disha Pandey, just sir, wait for 1 minute. Sir is joining. Provost Chancellor is joining. So just he told me just there is some connectivity. So sir wants to just in 1 minute he will join. If
Sir,
any other question
in
you can ask with the other faculties. Okay.
Sir, I have no questions as of now in my chat box. If you have any questions, sir, you can just put forward.
We have certain other questions. Sir, one more question is that there can be the is there any one more student has sent what is my complaint is not resolved through online dispute resolution. Do you have any other, because we have alternative dispute resolution. So what about if our ODR is not properly working, sir? Is there any other other remedy available to us? ADR is there with us, but is there any other remedy in our law, sir? The question of the student is like this.
No, no. What remedy can be? Either it is conciliation, mediation, and arbitration. There is no more remedy or than the fighting. Fighting you can have it. For that it is not recognized either under arbitration, conciliation, or mediation. You can solve the problem by fighting. Only that can be done, but that is not recognized under any of the act, and therefore only three methods are there: arbitration, conciliation, and mediation. Arbitration can be by settlement also, and the settlement can also be under section 30 of the Arbitration Act. If they want to be recognized, that has to be under the act itself. Otherwise, it will not have any uh, binding effect, and it will not be recognized at all. Thank you.
Thank you, sir. Sir, we have a question from Faiz sir. Faiz sir?
Yeah, thank you, ma'am. Very good afternoon, sir. I hope I'm audible. Sir, my question to you was a little broad one. When we talk about ADR as a means of dispute resolution, the very objective of ADR, why it came into the picture was that it was taking a lot of time. Speedy justice was not available, and the technicalities were too much. So smooth dispute resolution could happen. That was the objective. But somewhere down the line there is an element of compromise which is there as far as ADR is concerned, specifically when we talk about mediation. Parties compromise a little, that okay, I will give you this much and that much, and they come to a common terms. So don't you think ADR as a concept is something which is giving preference to peace over justice? uh, there is no uh, bitter taste between the two parties. Both are kind of happy, full, no more enmity between the two. So giving preference to peace rather than justice. So what is your take on this conceptual issue as far as ADR is concerned?
Justice, the question is of justice. Either parties may fight out on the merits of the case, or settlement is taken place. In both the places, settlement and the fighting on merits, both gives only justice has been done. Therefore, you can't say that justice has not been done. If the party agrees to the particular terms, then the justice has been done to that compromise also, and for that purpose section 30 has been inserted by the in this is arbitration and conciliation act. You just see section 30, that will be clear, that the party can compromise themselves. That will be also a justice between the parties. Why not it is justice? It is justice. Why not it is? Because Section 30 provides, if with in arbitration agreement for an arbitral tribunal to encourage settlement, that also provides to the tribunal to encourage the settlement. Suppose 20 रुपया आपका बाकी है, वो 5 रुपया देने को तैयार है, तो इनकरेज करता हूँ, ठीक है 5 रुपया ले लो, नहीं तो 20 का तो 30 होता चला जाएगा, बढ़ता चला जाएगा. बहुत सी ऐसी बातें होती हैं. Justice is always there, either in compromise or fighting out on merits. Both justices are there. Suppose in one case of the arbitration, I was just dealing with the arbitration matter where the parties owe a sum of rupees 103 crores. Defense has come. Yes, we have taken a loan, everything, but now I have prepared to pay 93 crores only and leaving apart 4-5 crores. Parties have said, all right, proceed with this, and the justice has come that in 1993, the crores, the tribunal has passed the award by way of settlement. Therefore, justice is always there, either settlement or fighting out on merits. Thank you.
Sir, I have one more question.
Thank
Sir,
you,
what
Rajesh
is-
sir. Rajesh sir, Debrati ma'am wants to ask a question.
Okay.
Let us first take her question.
Okay.
Ma'am,
Good afternoon, sir. I'm Dr. Devaruti Haldar. Am I audible?
Yes.
Okay, sir. Sir, when we are talking about online dispute resolution, I do understand that there are three parties, not three parties basically, but there is a fourth party is also existing. That is the media or the platform where such communications are going on. In this regard, sir, I wanted to ask what is the foolproof for the privacy of the discussions. We do understand very recently regarding this Aadhaar related issues, lots of debates, discussion came up. Now, what is your take, sir? What is your understanding regarding the privacy and confidentiality that may be given to the client communication from the lawyers, from the arbitrators, etc., sir? Thank you.
That act itself provides confidentiality. We can't disclose what we are doing or what the other side has said. It is between the two parties only, and we maintain the confidentiality also. We don't disclose what the other side has said. It is when we have arbitration or mediation, we don't disclose to anyone, and it gets only logged everywhere where the arbitration proceedings are going on. And for that purpose, conciliation also provides that it shall not be disclosed to. Even under section 70, it has been stated, when the conciliator receives factual information concerning the dispute from a party, he shall disclose the substance of the information to the other party in that order only, and then privacy shall be maintained. Only settlement when takes place, only two persons can do that and it is completely confidential. Nobody knows that. Even in mediation proceedings, what we decide, I never disclose anything. If the parties don't settle, then the mediation ends, conciliation ends. We don't disclose even reasons why it has ended, because in mediation and conciliation, other party says that we don't want to join for mediation and conciliation, then the proceedings are closed. We don't give any reasons, we don't disclose it, we don't say anything else. And where the award is made, then the reasons has to be made. Reasons, the award, if no reasons are there, both the parties have said that don't assign any reasons, we are settling the matter, then we settle the matter under section 30 of the Arbitration Act. If he says that the reasons are necessary, only then we give the reasons. Therefore, confidentiality is always there.
But sir, I also wanted to know about the issues of cyber security, since it is online dispute resolution mechanism. So what kind of security can be given what kind of assurance can be given that the platform on which the discussions are going on, that will not be harming the privacy confidentiality of the parties, sir?
That depends upon the parties. If they want to disclose to everybody, if the award is there, we can't help it, and we can't give any security to them that they will not be attacked by any party if the award has come. We can't say anything. They have to take precautions themselves. They have to take precautions either to make it public or don't public. We don't publish our awards. We only give to the parties confidentially, and we take down the receipt of it, or we send it online. Generally, we are now sending online all the awards, and it is purely confidential. Nobody knows it, and therefore there is no question of cyber security. It's not a not a hacking. It's not a identity theft. Nothing of the kind. Neither in the award nor anything. It is only a disclosure of the claims which he has demanded, and therefore the provisions of Section 66A of the Information Technology Act will not apply. That has nothing to do cyber security or anything else. Cyber security is a thing of Section 66A, where it has been defined. That is the punishment for identity theft. Whoever fraudulently, dishonestly make use of the electronic signature. Here, it's not making dishonestly or making use of any electronic signature. What the claim says and what the defense said matter. Thank you very much.
Thank you, sir. Rajesh, sir?
Yes, I have one more question. That sir, we have the cross-border dispute resolution. So, sir, can you explain how this cross-border dispute can be resolved by ODR?
It's a very simple thing. Nothing. That is the international commercial arbitration. That is the international commercial arbitration that can be done by online. I have also done sitting in Dubai. Online dispute, one party was of London and one party was Dubai. I have placed my sitting at Dubai and have resolved the arbitrations. There is nothing that is also guided. If it is one party belongs to London, it will be guided by the UK model law, and that has to be only procedure which has been prescribed, and all these are called international commercial arbitrations. Nothing can be done that can be done online. There is no problem at all.
Thank you very
Thank
much,
you.
sir. First of all, I am very much thankful to you that it was a very fantastic session by you, sir. You have, in the initial stage, you have explained about the Arbitration and Conciliation Act under Section 7, 8, 17, 31, and 15 and 30. You have also incorporated Section 89 of the CPC 1908, and you have also incorporated the various judgment, that is the Salim judgment, which you have explained under Section 89 sub 2, that was the substantial part of that particular judgment. And secondly, sir, you have also elaborated in a very fantastic way that how this arbitration conciliation work and how this ODR works in a more better way. And this concept has came in India, and not only in India but in the international aspect. The matter can be resolved in a very easy way. There are lots of advantages of this mechanism because the cost reduction is there, because we do not to go to the courts. We should not indulge in the lengthiest procedure. We adopt the various simplest procedure in this ODR. So on this note, actually, our provost chancellor was having some net activity, or there is some problem. He was trying from last 20 minutes, but he is unable to join. I do not know what was the problem, but he conveys regard that please give the regard to you, sir. So on this note, I am very much thankful to you, and now I will tell our dean, uh, Dean Madam, to say a few words and give a vote of thanks. Over to you, ma'am. Madam, you are not audible. Hello. Madam, not audible.
Now, am I audible, Rajesh sir?
Yes, 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 ma'am.
First of all, thank you very much, Rajesh Singh sir, for giving me the opportunity to talk. Thanks to you, sir. Thank you very much, sir. Sorry, Anand sir, thank you very much. On the behalf of our Institute of Law, Parul University, we are thankful to Honorable Justice Rajesh Tandon sir and for one of our sessions, you have enlightened us our students, sir. And we appreciate for imparting the knowledge to all students, and not only for the students, sir, but as well as for the faculty also. As I think that most of the faculty, Dr. Devarti and the Fayaz, Ayaz, all were all very they got continuously after the elections and they were highly interested. And again, I'm thankful to so for all the teachers that are part of these events. I'm very thankful to all of you. Thank you very much, sir.
Thank you, Manika ma'am. And now I will thank all the teachers and students for participating in this webinar. And the sir has taken a lots of pain to prepare this lecture. And no doubt, sir, we are not only stuck on this. We will have have in the future also association with you, sir. And you are always, whenever I call you, sir, you are there our institute and at any point of time, sir. So on this note, sir, we are very much thankful, and on the behalf of Parul Institute of Law, Parul University, Vadodara, Gujarat, we are very much thankful to you, sir. So on this note, we are closing this session. Thank you, Mr. Jiten Kobani, sir, who has given the live coverage on Facebook, and the entire session was given on this Facebook channel. So on this note, we are closing this session. Thank you. Thanks a lot, sir. Thank you, ma'am. Thank you, every teachers. Thanks a lot. So we are closing, sir.
Okay, thank you very much. Sabko salute. Looking forward opportunity to meet all of you at Gujarat whenever occasion arises.
Yes, sir. Yes, sir. Thanks a lot, sir.
Thank you.